started out the conversation together with effective strategies for resolving conflicts in modern times, and we're just talking about how advocates need to be mediation trained as well. So we can talk more about that as we move along this deck. We're finding out, especially as we're touching cultures and embracing each other across the world, that effective mediation takes on many forms. And the strategies for resolving the conflict now in modern times within all the effective strategies that we have is growing. So we're all learning and growing from each other as we encounter each one of the different venues of how culture touches culture. See, I'm trying to see how I can move this forward without, here we go. Excuse me one second. I'm not sure this is letting me move things forward. So let me go back up to the top here and go to myself to the next slide. So here we are. Here we go. I just want to make sure I have this, that you can see what I can see. Yes. All right. Let me go back to my slide deck. All right. So here we go with mediation. We do have a process in mediation. First thing, as the facilitated mediation process is ultimately about a distribution of power. We are making sure that everyone is empowered, including the process is empowered. And as facilitated mediators, we're very sensitive to the fact that we are sharing power at the mediation table. So when we go through the mediation process itself, even at the beginning with the introductions of everyone, we want to be sensitive to sharing the stage, sharing the power. Ultimately, at the end of the day, the facilitated mediation table is about how much power are you willing to give up, to have kumbaya, have agreement with all the other people at the table. What power are you willing to share? What power are you willing to give up? With this in mind, it's a different place in the legal system. Most systems in the legal system we're trying to keep power. We're trying to maintain power aligning with the law. We're trying to maintain a power aligning with arbitrational, contractual language. Facilitated mediation table is the only place where we're looking to have everyone empowered at the table as much as possible. What looks like a win-win for you and a win-win for everyone else at the table, that we're willing to give up a little bit so somebody else at the table can have a win-win, keeping it in mind that it's a win-win for us as well. So we start that off with our introductions. I introduce myself at the table, and I don't talk about myself at the table. I introduce myself, and then I turn to the other people at the table, and please share now how you would like to be addressed today during this mediation, and what role do you have? What is your title here today at this mediation table? The mediation process is taking the conflict, the whole conflict, and it's chopping it up into pieces. So the next point of the mediation process that I like to do, and I'm going to have my good friend weigh in as well at any point in time, is the business at hand. I like to set the business at hand as the wet concrete. We're not at the mediation process yet, but we're talking about the business at hand. What are the business points to a facilitated mediation? Does everyone agree to be here together for the 3-hour length of time? Number one. Number two, does everyone have the full authority to make decisions here at this table? The second half of this question is more important than the first half, without contacting anyone else. I can't get halfway down in mediation and find out that someone's got a cap to their authority. That's going to put mediating the moment of that dig in your heels, of that stopping point. That's difficult for me to handle. It takes extra energy. So I want to find that out in the beginning of the mediation process. Oh, you have a cap on your authority? Thank you very much. What is that cap? Oh, thank you for letting me know what that cap is, 5 million USD. Thank you for that. And who has authority above you? During the business at hand, I'm stopping my forward movement by taking care of the clarity and accuracy of someone sitting at my mediation table with a cap to their authority. So this question becomes very important, and clearing up of this question becomes very important as well. There's other business at hand, especially in mediations that are online. Let me put into the chat my email. Let me put into the chat my phone number. Let me put into the chat a link so you can open this this meeting up on another device in case we get disconnected. One time in Washington State, the whole mediation center lost power. Every county in Washington State, almost every county has their own mediation center, which is common across the United States. The whole mediation center shut down. Everything went dark. I finished the mediation with emails because everyone else put their email into the chat so we could finish. These are the things that are the business at hand, mentioning that mediation is not binding, non-binding until we all sign the agreement or until you all sign the agreement. Mentioning that a mediation is without prejudice typically in most courts across the land. It cannot be used in the court process against you unless we are mandated by a judge to share what happened in this mediation, or you are mandated by a judge. So these are the items in the business at hand. As we move into the mediator's opening statement, we're typically together in joint session with everyone, unless we have to use a shuttle mediation variation, which means I have to give my mediator's opening statement in this room, private session, which we call a caucus, and then I have to move over, whether it's physically in person or on Zoom, I have to move over into another room and give the same mediator's opening statement. Just depends on the rules and regulations and statutes of where I'm mediating, how I have to do this. And again, here we are chopping up the mediation process. We're chopping up the conflict. We're having everyone sit quietly as we explain the process. This is the mediator's opening statement that we give. And then we move on into the party's opening statement. And it's important to have, I'll talk about them a little bit more in depth later, but it's important that we make the process manageable and understandable. So I like to open the door, close the door. So I'm going to begin now with my mediator's opening statement. It's a transition sentence. When I stop, I said, thank you very much for listening to my mediator's opening statement. I'm exiting the door now out of that opening statement. I'm transitioning. You're going to be sharing your opening statements as we stay here together in joint session. Transition statements. The link attachment between my opening and now your opening. And I am always begin with the plaintiff. As you've brought the case, I've always begin with the requesting party. As you've brought this to the mediation table, more transition statements so people understand exactly what's happening. This is how we chop up the conflict. People are resting now. They're listening to us. They're not ready to blurt out the conflict yet because they have to listen to the mediator. We're giving space for relaxation at the facilitated mediation table. And parties give their opening statement, which is about the past. So as facilitated mediators, we explore more about the past. Then we disrupt their present motives that they have at the table because we want to have people ripe for negotiation. Unless we disrupt them off their reasoning, challenge their reasoning, open up their mind beyond their focused reasoning of what they don't want to have happen anymore or what they want to have happen today at this mediation table, people are not ready for negotiation. And that takes us all the way to the end of the process, which is drafting that agreement. Would you like to weigh in at all, my friend, right now?
No, you can, but because what I'm going to do is Kathleen is going through the actual mediation process, and the topic that we have is how to make it a success.
Yeah.
So I'm going to play a little bit of a focus on how do you make that as a success.
Very good. Remember, a great big dish of conflict is very difficult to handle. So what the success that's being talked about right now is so important. And what you're seeing in the beginning here is we break the great big process of handling conflict up into steps. And with these steps, we have these techniques and strategies that contribute to the later success that we're going to look at because people are having a fully empowered conversation. Fully empowered conversation says a lot. It's not just about one person feeling safe enough to air, to talk about, to be able to negotiate for what they want. It's also about the power at the table, everyone having fully empowered. Power to hang on to their power or to release their power at the table. This is the key of the releasing of my power, their power at the table. Am I still comfortable because I've decided to release power to align myself with someone else that wants power from me? So we need to think about power as everything being fully empowered at the table. So our transition statements that I've already shared with you, the strategy, the technique of that gives psychological safety, which is power at the table because things are fully understood. Oh, this is where we are right now. Oh, this is where we're going. Okay, I understand. Does anyone have any questions? Is also what we ask at the end of the mediator's opening statement. Again, full empowerment at the table. Reiteration summary is a technique that I use all of the time in the beginning when people are telling their stories. In facilitative mediation, we have a superpower of proving to people what we heard them say. It's our superpower. My judges never did it when I worked for my 6 judges in the courts south of Boston, Massachusetts. My arbitrators never did it. Reiteration summary is our superpower as facilitative mediators. Judicative mediators oftentimes don't do it either. They go right from the documents to negotiation. They skip over the opening statements oftentimes, and they are asking question after question after question after question after question. That is lawyering. That is managing. That is HRing. That is not facilitative mediating. A reiteration summary is when someone tells you their story or you ask them a question, you literally summarize back what you just heard. I like to call that a trifecta, which is a grouping of 3. Every time we hear somebody speak, we say, gratitude, thank you very much. Let me make sure I've heard what you just said. Number 2, is that correct? Looking for psychological safety, being humble as a facilitative mediator, being open to being corrected, being open to have made a mistake with my summary, giving power now to the party at the table to correct me, the mediator, the person that's running the process. And lastly, I ask the mastery question, number 3, is there anything else? I do this from the beginning after the opening statements, all the way through the mediation, including doing this with the transmitting of offers for negotiation when I reality check. These are very important techniques and strategies, and other things could be mentioned as well. Our challenges and solutions in mediation are basically in 3 areas. People come to the mediation table with their past story, and the story gets expressed in the documentation that we receive as mediators, potentially, if any. And the past gets expressed when they sit there at the table and you ask the open-ended facilitative mediator question. Instead of saying, what's your statement, which is a lawyering type of way to handle facilitative mediators, we say, what has brought you to the mediation table today? What has brought you? What subjective brought you is all subjective. It's a wide open question that allows people to start anywhere in the process, not having to put things in order as legal documentation usually is that I see before the mediation starts. It's the narrative, which comes from inside a person's storytelling ability, which comes from their heart, which comes from their gut, which comes from their pragmatic brain side, left side, but also comes from their right brain intuitive side as well. It's their story. The challenge here and the solution here, when people are telling their stories with their opening narrative, their opening statements, is to not interrupt them. That's the challenge. And the solution all at the same time. I never interrupt the narrative, except if I've heard a number wrong. Excuse me, could you repeat that number? Excuse me, I didn't hear that correctly. That's it. The challenge and the solution for the narrative is to not interrupt, because we want the story to come up out of the person without interruption, because their story is not in the left brain. Their story is in both sides of the brain working together, and they're mustering up the words under stress. When people come to the mediation table, they are under stress. The dispute attached to emotionality has now created a real conflict. And the challenge and the solution of this real conflict is when people are talking, when they're opening up the mediation with their story, to not interrupt them. Because if we interrupt them, the right brain will shut down, the heart message will shut down, or will pause, and they will go to their left brain to answer the question from the mediator. That's why I never interrupt the story unless I hear something wrong. The words that people are using and the emotionality that's tethered to the words are also from the past. And these words have meaning. That's why reiteration is saying exactly, using exactly every word I've heard and saying it back to them. The challenge and the solution here about the past story is to validate it, is to prove that I've heard it, is to give psychological safety. Your story's allowed at my table. I don't discard people from my table. I'm not in the rubbish removal business, because people are not rubbish. People are human beings. So I validate them. I say, thank you for what you've just shared with me. Let me make sure I have it correctly. I might need your help, so please correct me if I get my summary wrong. And I capture those words. I capture the value of those words they brought to the table, because under stress, those are the only words they had available to them. So I'm using those words. The emotions, I'm also capturing the emotional tenor. I'm saying, so thank you very much for your opening statement. And as your mediator, because I'm not there by myself, I'm there with my title, my process, and my mediation table. As your mediator, by your tone of voice, I'm attaching it to them. It seems like, has this been a difficult situation for you? See, difficult is subjective. Situation is subjective. I'm using subjective words inside my question to see if they're willing to share with me their emotional tenor. The past has documentation, narrative words, and emotions. When we move on into the mediation process, when we start to explore more about the past that we have found out past the opening statement, we get into the exploration of now the more about the past. And I want to know more about the beyond of what was shared with me in the opening statement, because the opening statement, their opening story, is the tip of the iceberg. There's more underneath that tip of the iceberg. So I get into exploration, more about the past. But when that's all done, when I think I really have a good understanding of everything, I'm asking questions beyond their opening statement now as we've moved into exploration, then I'm ready to move on to the present. The present is a merging of the past with the documentation, but it's also more accuracy about their story, more sharing about those questions, and disrupting them. How is it that you think that you can accomplish this here today at the mediation table? When you said this, what did you exactly mean? Did you hear them say that? The other parties say that in their opening statement? I am bringing my brain and my judgment into the disruption phase about the present, what they think they can accomplish here today at the mediation table, and I'm challenging that. I'm saying, what's been the overall impact for you regarding this situation? And if the mediation table would fail today, what's your worst case scenario? What's your best case scenario? I'm disrupting them by literally saying if this table would fail today. And I may do that in joint session. I may do that in private session. And then the last question I'm asking in the disruption phase, if the mediation table is successful today, how is it going to feel? Right brain, heart message, feel. if this conflict were behind you in the rearview mirror? Do you see the disruption process, how it takes someone from the mediation table failing to the mediation table being successful? And we're looking at all the options they bring up, and I'm disrupting them. Oh, well, my best case scenario, Kathleen, is I'm going to win in court. Oh, how are you going to win in court? As mediators, we never know what judges are going to decide. So how do you think that you're going to be winning in court? That's disruption. So that's the challenge and the solution at the same time, because the challenge is, as the mediator, to ask those disruptive questions according to how you're seeing how you're hearing what they're saying, according to what you're seeing in their documentation. How do you think you can get this accomplished? That takes mediator style, confidence, and courage to ask those disruptive questions, to challenge your client. And the reason that you can do that is because you develop trust, rapport, and bonding when you've listened to their opening statements, when you've explored more about the past. Because when parties give their opening statements and when people explore more about the past, I didn't challenge them at all. I validated them. I reiterated, summaried them. I said to them, seems like, sounds like, looks like, feels like. And then I took a mediator guess back in the past under our exploration stage. I've got all my trust, rapport, and bonding that I need now to disrupt and challenge. Lastly, the challenge and solution at the mediation table are into the future. As we combine the present conversation with option generation of offers, we brainstorm offers now to the other side as we enter our future phase, which is our negotiation phase. We are now negotiating offers back and forth. That is having people glimpse into that future forward, that do different future forward, as I like to say. How can we work this out with new meaning? People come to the mediation table with historical meaning. This is what I want, this is what I don't want. The mediation table is shifting the meaning because mediation moves. And this is one of the solutions. Keep the mediation moving forward. Don't leave behind historical meaning that still has meaning at the mediation table. Keep it with you, but you're creating new meaning and maybe merging it with historical meaning of what people want, what people don't want in the negotiation phase. That's why we brainstorm first. That's why the challenge of getting to a settlement agreement and the solution is to brainstorm offers to each other. And then I, as the mediator, reality test, best case, worst case, how is this attractive for the other person to receive it before I transmit that offer over. In negotiation, also, we have impasse. Challenge of the impasse is that people have dug in their heels. The solution of the impasse is that people have dug in their heels. So handling an impasse facilitative mediator way is, first of all, to say thank you for being willing, for being loyal to yourself still on this mediation table. Thank you for your loyalty to self. I hear it, I've been listening to it, and I see that it's still alive and well. That's a challenge to say that to someone, because most mediators look at impasse as, oh, we are stuck. We are not stuck. We have the clarity, we have the accuracy that we've been chasing. That is clear. And now your loyalty is to yourself. This is the new clarity that I'm finding out. Your loyalty is to yourself on this agenda item that we're trying to resolve for our settlement agreement. Therefore, since mediation has to move, as your mediator, I'm going to be asking you to start to release your hold on your loyalty to yourself. If you still want to continue to sit here, now I'm using my process, if you still want to continue to sit here at this mediation table, I'm going to be asking you to release your hold on this impasse, on this loyalty to self. I rarely use the word impasse, even though that's what it is. I rarely use the word, because a facilitative mediator will name it for what it is, loyalty to yourself. You've come to the mediation table to share your power, to share these issues, to figure out with everyone else at the table. And now you're maintaining 100% loyalty to yourself. Can you tell me more about that, please? That's the facilitative way of handling an impasse. as we move forward to settlement. So we have these beautiful facilitated mediator techniques that accept the challenge and present the solutions here as we move forward in this process of mediation. Here are some examples. The other week I was meeting a case in Washington State, and it was a joint mediation. Mediation number 1 is over. Now we move on to mediation number 2. As soon as I have a male client and a female client, and I'm co-mediating, I'm mediating with someone else, co-mediation model in Washington State, where it's mandated by state statute. Some states will mandate you cannot mediate by yourself. Under the court setting, you have to mediate with another mediator. And I noticed right away there's something wrong with the tone of my male client's voice. We have paraverbals. We have the pitch, our voice has a pitch, a pace, and a tenor. And in this situation, we left the first mediation with an agreement, and now this gentleman is coming to the table with this tone, with this depressed tone, with his body language like this. So I say, thank you very much. Let's go ahead and want to just go into the room and just talk to each of you privately before we start the mediation, because I noticed the tone of his voice, the tenor, and his body language. This is a problem to present this at the beginning of a mediation. Something is going on here. So the practical solution is to break off into private session and go find out. And the problem was this: Kathleen, I don't want to do these joint sessions anymore. I'm tired of listening to everything that she's talking about, Kathleen. It's a burden. It's painful to relive this marriage. This was a divorce mediation. To relive this marriage. I can't take it anymore. I want to continue this mediation in private sessions. So what's the practical application of that? Is to go to the other side and get permission for it to be in a private session. And we got that permission. And now for the rest of the mediation process until settlement agreement, we have private sessions, which is called shuttle mediation, where we will now be transmitting all the information between party A and party B, client A and client B. And when you transmit that information, the practical solution is you write it down, make sure you have it exactly perfect. I never verbally transmit anything in online mediations. I write it down. I get permission for their words. Now I've got their words on paper, and I read their words off the paper is how I transmit. Not my words, their words. Quickly, another case study. At the mediation table, somebody got mad and threw a pen. So what's the practical application of giving full empowerment to someone throwing a pen? The practical application of any emotional discharge at the mediation table is to clarify it and chase the accuracy of it, just like we clarify and chase the accuracy of the written documentation, just like we clarify and chase the accuracy of the opening story, the narrative, what's brought you to the mediation table. Now someone's throwing a pen at the mediation table. That deserves to be clarified as well. The people that told me about the story decided to stop the mediation because they were so upset and offended, the mediators, that someone threw a pen on the table. And I said, why? Why were the co-mediators using their power now to stop the process when the process is supposed to be about the power for the people at the table? Why are we not still chasing the clarity and accuracy of that emotional discharge at the table like we have everything else? Why now is the mediation stopping and people are going off into their caucus sessions, their private sessions, because one person threw a pen? Why are we vilifying the person that threw the pen as the enemy of the mediation table, which makes the person that did not throw the pen like the good guy at the mediation table? What has happened to our neutrality right now? What has happened to the equal empowerment of the parties right now? What have we just done? right now. And this is a common theme for mediators to do. The practical application of someone throwing a pen, my style, doesn't have to be your style, is, so I see that a pen has been thrown. Notice how I didn't say the word you. I see a pen has been thrown. I look at the person and I'll say, Rena, can you please look at me right now? Because that pen was thrown in a joint session where everyone was sitting together. Rena, can you please look at me right now? I'm creating a pathway with me and Rena, whether I'm on Zoom or sitting in front of people. Rena, that pen being thrown, can you tell me more about that, please? Rena's going to tell me more about that. I'm going to summarize what Rena said. And I'm going to say, Rena, is that correct? She's going to say yes, or maybe correct me. And if she corrects me, I'm going to say, thank you for that correction, Rena. And this is what it is. Is that correct? Rena's going to finally say yes. And then I'm going to ask Rena, is there anything else? And Rena's going to tell me, and I'm going to summarize that. And then I'm going to say, on a scale of 1 to 10, with the throwing of that pen, how upset are you right now? How frustrated are you right now? I'm going to grab the word that Rena used. I'm frustrated, Kathleen. I'm upset, Kathleen. How, on a scale of 1 to 10, how frustrated are you right now? 10 being the most. Right now is secret code for temporarily. And Rena's going to tell me, I'm an 8 frustrated, Kathleen. I'm going to say, thank you for that 8. Now I'm practically turning to the other side in this case study, and I'm saying, please look right at me as well. How was that for you to hear and see on a scale of 1 to 10? People are going to tell me. I'm going to summarize what they told me. And I'm going to say, is that correct? And they're going to tell me yes or correct me. And I'm going to summarize the correction. Oh, it's this instead of this. And then I'm going to say, is there anything else? Just like I did with the paperwork. Just like I did with the opening narrative. Now I am chasing clarity and accuracy of the emotional tenor that was subterranean inside people that I couldn't see because their body language didn't show me until the pen was thrown. And then, because I'm a facilitative mediator and not adjudicative mediator, not a judge and not an arbitrator, I'm going to say, so thank you very much for this clarity. What would you both like to do now? But I'm going to say it in a special way. What do you both need right now? Need is subjective. Need is emotional tenor. What do you both want right now is intellectual. It's not emotional tenor so much. Need, every word a facilitative mediator says matters. Every word has a metaphysical gematria, pressure to it, a vibration to it. Every word. What do you need right now? Guess who's going to tell me what they need? They are. I'm not going to tell them we're breaking into private session. They're going to tell me what they need because it's their facilitative mediation. And I'm not sitting in an evaluative chair. I'm not sitting in the chair of the judge. I'm not sitting in the chair of the arbitrator. I'm sitting in the chair of the facilitative mediator that has a process in front of her of loving kindness, of full empowerment. And I don't look at people as refuse. I'm not discarding people from my table. I'm not removing people. I'm not in the removal business. I'm in the big hug embrace business. Stay together here at the table as much as possible. So the conclusions and takeaways before we move into potentially your questions as we maybe take a break here is justice has a feeling always. Winners and losers in court, that goes along with a feeling. One feeling is the feeling of getting the win, which might not feel like a win to everyone because it's sad to potentially see someone lose. The other side's got the feeling of how to deal with loss. Justice has a feeling. Injustice has a feeling as well. That is felt at the mediation table. That's why we pay attention to the emotional tenor. We pay attention as facilitative mediators to the concise facts. How do I pay attention to that? Those concise facts? Because when someone says something at the table and I've got my documentation in front of me that disagrees with what someone just said, chasing the clarity and accuracy of what was just said is now merging it with the document information. And I will look at my document and say, hold on one moment, please. I'm looking at my documents, page 4, paragraph 3, line 25. And this is what I'm reading. This is what I just heard you say. I'm going to summarize it, and I'm going to say, as your mediator, I don't understand now. Can you help me with this, please? This is how beautifully, carefully, the human way of moving gently with people that happens at the facilitative table. When it's a purely beautiful facilitative mediation table, when the mediators have the skill set to move this way, this is how I get my concise facts, by saying, hey, I've got a disagreement here. I'm a mediator. I need agreement. I've got some disagreement here that I need cleared up. Because at the facilitative mediation table, honor, the currency is honor. Everything we do, everything we say, our smile, our paraverbal, our tone of voice is our currency. And our currency is honor. Our currency is giving all the time people at the table affiliation, appreciation, to give status at the table. We are giving status at the table to everyone else, even the process, all at the same time. And our life is on hold. We checked our ego at the door before we entered the process of the facilitated mediation process. We are affirming people. We are affiliating them with each other. We are affiliating them with the process. We are affiliating them with agreements. We are affiliating them with the future settlement agreement. This is all about status, moving the whole way along. We understand that people are coming to the table and redefining their lives. They're going from conflict with emotionality attached, tethered to disagreement, full-blown conflict. That's why the pen throwing doesn't bother me at all. Depending on the culture that I'm mediating in, it might bother the other people because it's against culture. And now I've got to clean that up as well as the mediator at the table. We know that when they come here, the agreements that they're affiliating themselves with, the negotiations that they're willing to let go of something to get something, is a redefinition of their lives. And we understand when they walk out into their world, this settlement agreement needs to work. It needs to be effective. It needs to have longevity. So when I worked in a mediation center as a coordinator for 5 courts in central Massachusetts with 36 volunteers, I made sure that all of us understood that we were redefining people's lives in small claims court, in landlord-tenant court, in family court of divorce, life dealing with children. And divorce is now about not adding to your life anymore, not adding a family to your life, not multiplying things into your life. It's about subtraction. It's about dividing things away from your life, creating whole new cultures of how do I live solo when I had these circles of living and meaning of living together. Now I'm living by myself. Redefining of life. We understand at the facilitative table that this is all very, very, very important. So we approach it very gently at the table with our mediator skills, especially with our paraverbals. So with all of that being said, we'll take a moment. Does anyone have any questions or comments that want to be shared right now? And I'm also going to go ahead and put this slide deck into the chat so everyone else can have it to look at it for themselves as well. So Rena, let's take a couple of minutes and see if we've got some comments or questions.
I think because due to paucity of time, maybe we could move ahead in the session, and maybe if they have any doubts, they could put it in the chat box and we'll answer at the end of the session. Does this sound good to you?
Absolutely.
Okay, so I think you can.
Yes. So what I'm going to do today is I'm going to deal with all of you on the presumption basic knowledge of mediation, and those of you who didn't have had the benefit of Kathleen's presentation, where she has explained the process and she's been telling you as a mediator what she's going to do. I'm going to focus as to how you are going to make that mediation a success. Now, to understand this, we must understand that in a mediation room, there are three distinct parties. One is the mediator, two are the parties, and three are the counsels. So each one of them has got a specific role and a requirement or an obligation to make it a success. Let's start with the mediator. And I won't dwell much long because you've heard Kathleen how she's been so thorough, precise, and the way she goes about it to ensure that the dialogue keeps moving. But before you start as a mediator, those of you all who want to become mediators must understand that the dialogue process is done in a particular space and time. And imagine that you fixed the dialogue process to go on right through the lunch break. And somebody who has a medical problem, who needs a glucose fix, but he's stuck in mediation, his concentration levels are going to go down. Or if a party has a requirement to go and collect his kid from school, and you fix the mediation timing during that time, his mind is not going to be in the room. His mind is going to be, oh my God, I've got some other obligation to do. So the mediator, if he wants to make the mediation a success, has to prepare and plan his schedule, taking into account all the nuances and intricacies that may affect the parties in the room. This is the first thing. Two, if you are doing an online one, then remember, if one of the parties is in a time zone that's a sleep zone, you are not going to get him attentive at some other time. Two, if the party is in a climate zone, that's like in India, very heavily raining and the possibility of flooding, his online connectivity could fail. So therefore, if you are going to make it a success as a mediator, you need to prepare and plan taking all these contingencies into fact. Two, if you are a counsel, your preparation starts much before the mediation. Your preparation starts at the time when the decision to mediate is made known. Because you have to choose your mediator. You have to do your due diligence about the mediator. Is the mediator a facilitative type? Is he an evaluative type? That's his dominant trait. Is he a transformative mediator? What are his dominant traits? Because you need to understand what type of dispute and clients you have. Are you sitting with a client that has a power imbalance? And you need the mediator to be able to fill in that gap. So therefore, this preparation, you can't expect the party to be able to do it. It's for the counsel to do it. The lawyer who decides and advises his client will say, okay, fine. We have been offered an option of mediation. Here is the panel. These are the ones that I've seen. Let me do a due diligence, find out with them a little more of their background. Are they suitable to us? Are we comfortable with him? Can we build a rapport? In some cultural issues, there are issues of caste considerations. Is the person who is going to come in as a mediator or someone that I can be comfortable to share confidences? Can I open my heart to him? He may be perfectly okay. You've never met him in the past, but you're not confident, you're not colored, you have biases, he has biases. So therefore, this preparation is a very, very important thing, because biases or other influences can cause what I call hindrance, obstructions, or potholes in the road to a successful negotiation. So this is it. Now when we come to the client, the client really knows nothing about dispute resolution. All the client knows is that, yes, I'm in trouble. And my issue is that I come to the profession and the profession is supposed to give me a solution. And the lawyer says, okay, the solution is in the law, it's in the statute, and this is the process that you go to court. And suddenly you tell him that, no, this is mediation is a process where you are in charge. The process is yours. You got to handle it. You got to negotiate. You got to do something. And therefore, the client now suddenly feels, what am I going to do? So that is at the time when the client needs to prepare with his counsel, what does he do? How do they, to understand the concept of mediation, to understand the pitfalls, to understand, most importantly, the negotiation. Because all those of y'all who have learned negotiation in the principle knows that this negotiation to succeed needs leverage. I'll give you something if I can get something. What do you want and how can I give it? These are the leverages. So therefore you need to prepare these leverages. You need to prepare your partner and your partner with the client and counsel together so that you, when you come tomorrow, you know the limits of your negotiation. 2, you need to know the problem of the first peg offer. So how do you make the offer? When do you make the offer? And if there is some information that is contentious to be disclosed, then how do you handle it? So these are all matters that require preparation. And in my experience, especially in court annex mediation, parties simply come to the room because they have been sent to the room by the judge. They come expecting nothing or sometimes expecting the sun, little realizing that it's not just sun but it's also going to be a little bit of rain and you should have brought an umbrella along. So therefore, preparation is a very important element if you want to make it to succeed. Another very important aspect that counsels, and including the mediator, should know what a SWOT analysis is all about. SWOT stands for strengths, weaknesses, opportunities, and troubles. Strengths and weaknesses are internal. It's what you have, what are your strengths, what are your weaknesses in the dispute. Opportunities and troubles are external. What are the opportunities that can add value, increase the pie? What are the troubles that can take a decision away? So this is a SWOT analysis. So it is important not just for the parties to do a SWOT analysis, but also for the mediator in caucus to ask the party, look, what are your strengths? You come here with a certain agenda in mind. What, according to you, are your strengths to succeed? What are your fears that you will not succeed? So thereby, the mediator gets a feeling of what is the partner and the what. He would also ask and explore what external factors can influence the decision making. Is there a new legislation going to come on? Is there some pricing that is going to come on? Is there windfall profits that are going to happen? Is there some threat of a project of a competitor that's waiting on the side? So all these are exploratory concepts that the mediator can look at and thereby try to make the dispute, transform the dispute from one arena to another arena to find a solution on a wider scale. So therefore, when we talk about preparation, we need to actually look and work this in much more detail. And when we talk about detail, we must have time at our hands. So you can't come to a mediation expecting a quick fix. It does not happen. You can't come to a mediation under pressure or stress of time. And most importantly, for a mediator, he must remember that if he gets a settlement under pressure, the likelihood of somebody pulling back from that settlement or rescinding from whatever has been offered is quite high. Similarly, if the mediator allows the parties who have reached some sort of understanding without binding them down, he ends up taking a risk of a third person influencing and creating problem into the effort that was gone on the last day. And the next day you come and you find that everything is gone back like snakes and ladders down to back to one. So you're starting from zero all over again. So therefore, when we talk about preparation, and in some of my negotiations, especially in labor matters, it has gone on throughout the night, right up to 2 a.m., 3 a.m. in the morning. Why? Because each side was scared that if they walk away, they are not going to be able to come back at the same position again. But the problem was, for the mediator, or rather for me at that time, is, are the parties weary and tired? Are they able to comprehend what is being made and offered at the table? So therefore, breaks become larger, breaks become important, and sometimes additional stuff is required besides tea, coffee, snacks, music, soothing stuff. I know of a number of mediators down who use incense, who use smelling oils, who use soothing music, who use different lighting diffusions to create an essence of relaxation. So these are the things that you prepare the arena in which the parties are going to play. For example, if you want your football match to succeed and your team that's going to play has always been practicing on AstroTurf, they are not going to be able to play good football on grass. They are definitely not going to play good football in a flooded football field. So therefore, you need to understand and create the environment. This is the most important thing. And for the party and the council, you need to also convey this information to the mediator, because the mediator does not have a divining rod to suddenly see a broad picture like one of those women that you see in movies deciding your future in a crystal ball. No. So therefore, some information must be made available to him. Some information must be shared with the mediator. So this is something that is important. Now, the other very important thing, especially in commercial mediation and in family mediations, is to recognize prejudice and bias. Because prejudice clouds the mind. Bias affects the decision making. So therefore, we must be able to understand what are the prejudices that the parties come with. So in a business, especially in commercial business, one man may have a problem with a person from a different community. He may be a person who has a chip on the shoulder, a young entrepreneur who has struggled hard, vis-a-vis another entrepreneur who had been born with a silver spoon. They are on two different angles. They have a prejudice. So the idea, it becomes much more difficult to carry the offers and get people to understand understand on a similar plane. Because you will find, as I found it very often, that somebody says, it's very easy for the other guy to talk. He's had it, everything available for him. What is there? He's got influence, he's got money, he's got everything. I've struggled. And he's breached my contract. I suffer. For him, it's nothing. He says, how much money do you want? Money is not everything to me. My reputation, my prestige. How do you handle that? Now, you can't put a monetary value and he is not looking for it. Now, how do you address as a mediator that to happen? And as a counsel, because you want your case to succeed. You know very well that even if you go in a litigation, what the court can give you is only summary damages. The court can't put a value to your reputation. The court can't restore your reputation. What is done is done. So, therefore, in mediation, you need to prepare by having a reality check that, okay, this has happened. What can we get? So, you need to prepare your ZOPA, your zone of possible agreement. And that is the line from the time you start your opening statement to somewhere when you do your joint discussion, that the mediator has to be able to find the ZOPA and ensure that the parties are negotiating in tune with the ZOPA. That is, imagine, both parties have no ZOPA, but they have an agenda. And they have decided that, okay, let me throw ideas left, right and center. He's throwing 20 ideas, the other side is throwing another 20 ideas, 40 ideas on the table. 25 impractical. The rest 15 require a hell of a lot of work to be done to make it workable. So therefore, if there is a ZOP whereby the SWOT analysis will be able to help you to create that, look, this is what has happened, this is what I need, these are my interests, how do I achieve it? What do I require to achieve it? And what do I have to get? Because remember, there is an organization known as the BNI, Business Network International. And they have a very famous saying, givers gain. If I give you something, I'm sure you will give me something back. So this is basically the essence of commercial negotiation. I need something. So I will ask you, what is it that you want so that I can achieve what I need? How can I help you so that I get this figure? So these are some of the basic requirements if you want to make your mediation a success. Now, another thing when you're doing your mediation training is, you must have heard of something known as expanding the pie. Now, expanding the pie is very simply, to those who haven't heard it, imagine that you've gone to one of the famous pizza shops. 4 of you all have gone to a pizza shop, and that chap tells you, yes, there is here a 4-inch pizza, there's a 6-inch pizza, there's an 8-inch pizza, and there's a 12-inch pizza. So there are pizzas of different sizes. Well, 4 of you all decide that, okay, fine, we look at your finances, a 4-inch pizza will do. It's cut into quarters, 4 of you. But each one has got an equal quarter, perfectly in agreement with what each one thought about, but it doesn't satisfy the hunger. So you need to have a larger pizza to satisfy that hunger. And that's basically the concept of what is known as increasing the pie. So when you have a road to travel, you know what you want, but there is only this much available on the table. So the 2 of you all can work together to see how something more can be brought onto the table. What more can be added so that you take back more? How can we generate more income so that we take back a greater amount, so that it satisfies not just the need, but it satisfies the hunger too. So all this requires, in a short nutshell, is preparation, preparation, preparation. So I would then encourage all of y'all who want to make your mediation a success, understand this, your preparation. The second thing that is important, especially to mediators as well as to mediation counsel, the lawyers who are going to be in there, is learn about the whole fundamentals of mediation. And remember, if you have studied this 10 years back, there is a vast improvement in techniques. There is a vast advancement in concepts. So you need to constantly upgrade yourself. You need to constantly relearn. And especially today, when there are offers of what is known as hybrid formats, online formats. Sometimes the word Kathleen say that, okay, fine, we'll only do it by email around. So there are various means of communication which you need to keep relearning or learning in the first place. Because if you are an unlearned person or a half-learned person, you are not going to be able to make the best of the opportunity. It's like somebody gifting you a Mercedes car. Fantastic. Everybody looks at it and you haven't read the manual at all. And you then sit into the car, you know how to drive, so you start it on, it goes on, and suddenly you find that I don't know how to handle the music systems because I've not read the manual and it's not like my old car. So therefore, if you are going to get the benefit of the whole bundle of mediation, you need to know your fundamentals. You need to know your techniques. So therefore, you need to learn, you need to upgrade your skills regularly, and you need to constantly improve by understanding. Now, one of the problems in learning is, of course, what you will get in classrooms is theory. You rarely get an opportunity to see, because mediations are considered confidential and only parties can be there. And you don't want to start learning mediation by having your problem constantly mediated for the last 10 years so that you get a 10-year certificate. No, that's not what you want. So how do you learn? And one thing I tell students and young mediators, attend competitions. Look at competitions online. There are students, there are coaches, they are giving them ideas, they are giving them skills, they are giving them techniques. You are going to see that. That's available. And you are then going to be able to see how you can incorporate it in your practice, whether as a mediator or whether as a mediation counsel.